Hello friends, this is April Harris Jackson at Graceful Aging Legal Services. Again, I am an attorney licensed to practice in Tennessee, and our topic is conservatorships. If you have a conservatorship or guardianship matter outside of the state of Tennessee, I would encourage you to talk to an attorney in your jurisdiction. And if you have any questions that are specific to a situation that involves you or someone you know, I would encourage you to talk to an attorney who can give you specific advice about that case. So today I want to talk about guardians ad litem. So a guardian ad litem gets involved in a conservatorship matter pretty early, within 10 days of filing, usually earlier than that. Now there are situations where the guardian ad litem can be waived, but it's pretty rare. And the guardian ad litem has a pretty specific role. Ultimately, they are going to be making a recommendation to the judge, telling the judge a couple of things. First, they will have reviewed all of the documents that have been filed, that petition, the physician's report. They're going to do an investigation and talk to, they're going to serve the respondent and advise them of their rights. They're going to review that physician's report and see whether the alleged disability and the medical history that is reported on the physician's report kind of matches what they're seeing presented by the respondent. They're going to talk to the proposed fiduciary, who again is often the same person as the petitioner, and make sure that the person who is the proposed fiduciary, the proposed conservator, is the best person to serve. And ultimately, they're going to make a recommendation to the court. One, does the respondent need a conservator? And two, who is the best person to serve? Is it the proposed conservator, or might it be someone else? Now, again, they're going to go through a lot of steps, a lot of investigations to determine this. They're going to have access to a lot of personal information about the respondent, medical, financial information. But they're also going to have access to a lot of personal information and be asking a lot of personal questions of the petitioner / proposed conservator. And that's because they want to make sure that they are taking care to make a valid, safe recommendation for what will be in the respondent's best interest. So they may ask for a lot of information, they may ask for specific documents, and ultimately they often make a recommendation that the proposed conservator be appointed, but sometimes they don't. They are often going to ask for, what do we plan to do with the respondent's money? They might make a recommendation about that. They will often make a recommendation about bond, accountings, things like that, at the judge's request. So that's kind of the guardian ad litem's role. They're going to meet with the respondent, they're going to advise them of their rights, do all of these things, and they're going to be primarily in touch with the parties themselves. So it's okay for them, even though they are a lawyer, to be in touch with the parties directly. That is within their orders, that is within the rules of civil procedure, that is within the statute. But they will also communicate with the parties' attorneys in order to keep them apprised of the case. Okay, so that is the basic function of a guardian ad litem and their role in a conservatorship case. I hope this has been helpful. And if you have any questions or comments, I hope you'll leave comments below, and feel free to contact our office with any questions you might have, especially if you have a specific case that you are pondering about. Okay, well, that's it for today, and I hope to see you all tomorrow. Thanks, y'all.